Hi comrades, yours Kayveeyes. A very big blow to the RTP case because of the Madras High Court judgment. Let us discuss in short about this. The Madras High Court, while disposing the writ numbers 13633 of 2020 and others on 24/1/2023, observed vehement and against the earlier judgments in favor of the reserve train pool officials in the postal department. The judgment is very adverse. In case, if the department has produced the judgment before the RTP case in the principal cat, we may have some upset also in the principal cat judgment also. What it says in the judgment, they are mentioning that the Mathivanan APS case, that is the first case against the RTP, and thereafter only we are filing subsequent cases on RTP. So they are mentioning Madhivanan APS case is an exception and it cannot be a rule. Financial burden of implementing such a decision which has no element of legal justification. They are mentioning there is no legal justification in the RTP case, but it will increase the financial burden to the government of India. Third, they are mentioning the delay cannot be unexplained and unreasonable. They did not approach the legally till 2013. Only after the judgment in favor of the casual laborers, they are approaching the court. A dead cause of action, it cannot rise like a phoenix applicable in this case. Financial implications could be very stressful to pay back wages from 1984. The primary object of RTP was intended only to reduce the expenditure on overtime. They are not recruited as regular postal assistant. CAD decision would defeat the very purpose and concept of the RTP. The difference between the casual workers and RTP was the assurance to the latter of regularization. Demand for consideration of their service for all purposes, including TBOP, shows only greed in them. Government of India Exchequer cannot be allowed to bleed to meet such illegal demands. Supreme Court in CA number 80-123/1996 held any service prior to regular appointment cannot be taken for any purposes and dismissed the Ernakulam judgment. Demands are totally unethical and unreasonable. The previous judgments also set aside, like 1149 of 2014, 1691 of 2016, 1148 of 2014, etc. This is the main crux of the judgment delivered by the Honorable Madras High Court on RTP case. They are totally rejecting, and also the previous judgments which were issued in favor of erstwhile RTPs in the cases of 2014, 16, etc. Everything they are set aside. Not only they are set aside the present case, they are set aside the previous cases also and created a pandemonium so far the RTP cases are concerned. They are saying they cannot equate with the casual labor, and also Madhivanan case is a entirely exception that cannot be taken, and also they are approaching the legal remedy at a very later date, and paying from 1984 is unreasonable, and they cannot ask like a phoenix declaring that this is a dead cause of action and everything. If you go through the judgment thoroughly, actually our blood boils. A genuine case, RTP case is a very genuine case which has to be settled in favor of the staff, the aggrieved officials. That has been totally rejected by the Madras High Court. A very precarious situation has been arisen here. It has to be seriously fought at the national level because the case is pending, the case is coming for hearing this month. Naturally, the central headquarters should take more initiative to discuss the case once again with the advocate because of the changed atmosphere after the issue of the Madras High Court judgment. It should discuss with the advocate very seriously, bringing with other points and the points which are very valid to be fought before the principal cat, and that is the need of the hour. The RTP case should be dealt with full dedication and also full determination. With this, I am concluding this episode. Thank you very much, comrade. Meet again.